Hello, my name is Marlon Lopez, and I'm a full-time professor at the Law School of Tecnológico de Monterrey in Monterrey, Mexico. I'm a specialist in intellectual property with many years of experience in that area, and I am a professor of various courses, including topics of copyrights, patents and trademarks, and other related topics to internet. So I'm going to talk about the relationship about artificial intelligence and copyrights in this video. And I will mention that there are basically a few debates. The first debate about this topic is the simplest one, and it doesn't have too much area for discussion. If one author or group of authors create a computer program that details the functioning of artificial intelligence, and that program it can be protectable, the owner or the owners are the creators and the authors, and the one who first made the software in a material support is the one who has the right. That's what the Article 5th of the Mexican federal copyright law says, that the protection given by the law is since the moment that the creation is fixed in a material support, regardless the merits, the objective, or the way of expression. And the recognition of those copyrights and the neighboring rights do not require any registry, documentation, or that are not submitted to the formality or any formality. So in this case, we will be talking about work created by human beings. A different question, which is more complex, will be what will happen if an artificial intelligence creates by itself a computer program. That will be a new thing, a different. And in that case, the artificial intelligence autonomously, without any human intervention, creates another program. As far as we know, that situation hasn't happened yet. That scenario is not yet happening, so it's not an issue right now. But in the case it will exist, it will be very difficult to include that case in the concept of human rights. The Universal Declaration of Human Rights, in the Article 27, it says that any person or every person has the right to take freely part in the cultural life of the community and to enjoy the arts, participate in scientific progress, and the benefits resulting out of them. Also, it says that every person has the right to protection of the moral and material interests correspondent for the creation of scientific productions, literary or artistic productions of the author. But as we said, it mentioned clearly that has to be a person. Actually, there is a case in Mexico in which a moral person, a legal person, claims the inconstitutionality of Article 12 of the federal copyright law because they are excluded from the possibility of being considered authors. And the Supreme Court, in the first chamber, said that the Article 12 of the federal law of copyrights respects the right of equality and no discrimination, because the distinction is implicitly only to recognize the physical persons as authors. And they granted that as an objective and reasonable analysis. So what the Supreme Court said basically is that the legal persons cannot say that the law is unconstitutional because they don't have the right to be considered authors. So if the legal person cannot be considered author, the artificial intelligence neither can be considered author. That would be a very good analogy. The second debate is probably more complex because a list of instruction or parameters given to artificial intelligence to make a function, they're finally a text with certain significance or meaning. So if we would want to grant that as an authorship, we will have to accept the possibility that that text or instructions can be protected until the copyright as a literary work. And not only to be protected to avoid its reproduction and any other purposes, but also about its use in industrial or commercial application. So in theory, if someone else wants to um, make an input of the same list of instruction or text to an artificial intelligence without infringing the copyright of the original document, it would be a very good question to know if the result created by the artificial intelligence with the same instructions twice in a row reflect an identical result, a similar result, or a result completely different. Because finally, that comparative is relevant to the final result of the created work. As far as I know, the result will always be different. So it doesn't matter if you put exactly the same instructions, just the mere fact that you do it not at the same time in the same computer, but if you do it in different moments or in different um, computers or navigators of artificial intelligence, that will give you a complete different result. It will never be exactly the same. A third debate about this topic that it probably requires more analysis is that depending how do you focus, it could be that artificial intelligence will be regulated by the actual norms that already exist, or if it's required to create modifications or additions to the law. I think the most important thing to know if with the regulation that we already have that can solve the legal issues that we have, or we need to make changes. So to initiate with this analysis, we will say that Mexico, the federal copyright law, establishes first what is the author right, and it's the recognition from the government or the state that a right that has the author to have an exclusive privilege about his works, its creation. So Article 11 says that the author right is the recognition made by the state in favor of any creator of literary works and artistic works, included in the Article 13, where is the list of types of works, in which is given the protection for the author to enjoy the privileges and prerogatives exclusives from personal and patrimonial character, including the moral rights and the patrimonial rights. So at the end of the day, the recognition that the state is making of the creators is that it's a recognition, not a right or a grant given, but a recognition of an already human right that the creator already has. So it can be only attributable to human beings because of human rights, and they recognize those as human rights. The state recognizes those human rights as rights, so they are not granted or given. So we have three obstacles to give an author right as a result of something created by an artificial intelligence. The first one is, as was already said, that the law requires that the authors being physical persons. So that excludes the moral persons or the legal persons, which are legal fiction. And also this one this one can be title holders of patrimonial rights, but they cannot be recognized as a moral right for the creation of the who are copyrights. In second place, artificial intelligence they don't have any personality, and it cannot be a person, physical or moral. So, other than the plants, animals, or things, that is not susceptible of granted or given rights and obligations. The physical persons require personality, legal personality, since they are born, according to Article 22, the legal capacity of the physical persons, it's acquired by being born, and it's lost when you die. In the case of the legal persons, it's because of the legal constitution. So the legal persons, they can be obligated by the representing organism that has the power of attorney to represent them in their relationships. So the civil code establishes those limits, and also they make a list of what can be considered a moral person, a legal person, which includes in the Article 25 the nation, the states, the municipality, the public corporations, the commercial entities, the civil institution, associations, and some others. But at the end of the list, we see that we don't have anything related to anything that can fit the artificial intelligence. So in any of those cases, nor the physical person, not the moral person, or the legal person, can the artificial intelligence fit as a title holder of rights and obligations. Finally, the two reasons why artificial intelligence, as much as it is autonomous, it necessarily requires a human participation. Otherwise, if we give an artificial intelligence and we let them work by itself, only taking dates, data, and instructions randomly, they could have some results, obviously, but it would be like a machine bringing a picture or paintings randomly in in a wall or in an area where you're going to paint that, and to establish that that result, it's a painting in the artistic concept. So to to have that as a consequence that that's a work of art, which is not. Actually, according with the World Intellectual Property Organization and many other legislations around the world, uh, in a copyright or an outright, it has to be value the works because the human interaction is minimum or inexistent. That description or registry of what work, it can be resolved legally in the following way to, to refuse the protection of the copyright with respect to the generated work by the computer, or to give the authorship of that creation to the creation of the program. I really don't think that the creator of the program should have the right, because to create the program is not to create the work. And if the other person didn't have no intervention or is minimum, they neither should be considered out. On the other hand, the federal Mexican copyright law determines the list of types of works that can be protected, which include the literary works, the musical works, dramatic, dancing, pictoric, and drawings, sculptoric, plastic, uh, um, and architectonic, cinematographic, and audiovisual, radio and television programs, computer programs, photos, and applied art. And so to include artificial intelligence in that list, it only can be done in computer programs by itself. And if they create some of that kind of work, we'll have to see how they make it in order to understand how it works. Also, the law says that any other work that, for analogy, can be considered literary or artistic, also can be protected with the most similar area of the list. In these types of works, some of them can be created by artificial intelligence with some tools, necessary tools, but also the parameters, again, the established parameters only can be assigned to human creativity. And that person who has the human creativity is the one who can be legally the owner. In this same way, a tribunal of the justice consider that a work must reflect the creativity of the author in order to be considered. There are many cases that have been happening, discussing these issues with different resolutions about that case. But it's very important to recognize that one of the objectives of the copyrights is the creation of artistic and literary original works. So that's why that recognition to the author is given, and that's why the moral rights are given, because the public gives recognition to that person, and also the patrimonial rights for economic benefit. But which merit can we have to ask an artificial intelligence to make 100 songs or a doctoral thesis or any other uh, sophisticated result or a full book or a cinematographic script, or any other, if this result created is only a product of artificial intelligence and it didn't have any creative um, input from the output or is not significant that created input. So since from this point of view, the point of view of academic point of view, the result of this is like a student who asked the artificial intelligence to make an essay that is a homework about a specific topic, and that student didn't create that essay, only mixed the knowledge and text that already existed on the internet in a very significant number to create a distinct product different from the ones that already existed, but it's not really created by the students. Okay, if we give the copyright to those results, then the companies can not only hire artificial intelligence to do whatever they ask it to do. So the editorial industry will no longer need writers. The music industry will not require authors of the songs, and the cinematographic industry, cinema industry, will not require people who write the scripts. So it will be easier, just and very cheaper to hire an artificial intelligence to create that function, and that completely destroy the copyrights in the long term. So once established that artificial intelligence cannot be the owner of a copyright, we should talk about the other side of the coin. What will happen if the artificial intelligence can infringe the author rights? So already protected by third parties. In this analysis, it's necessary to compare what it happens in the physical world with what artificial intelligence does. If you read 100 books or novels about vampires, and then you write your own novel of vampires, are you infringing the copyrights of those previous 100 authors? The answer is no. Regardless, if you take paragraphs, substantial paragraphs of any of the works, it's necessary to cite the original source. So in order to not infringe the rights of that author. So this is something that actually the artificial intelligence they don't do. But maybe it's not that hard that they for them to do it. So if artificial intelligence use a section of a certain extension from a certain source, maybe they can just make a citation and put a link about the location of that information in the World Wide Web, and then we will have like fair citation and fair use, and everything will be okay. So I think that's a very easy solution. This is especially important because um, with, without the fractions of the copyrights, you can have fines and the claims of damages, but also criminal sanctions. Okay, so there are many resolutions and laws that talks about that infringing the copyrights not only have fines or civil responsibilities about the damages, but also it can uh, result in criminal infractions, and eventually you may have a very hard or very uh, difficult or very hard sanction, and eventually can end up in jail. So in another scenario, if a person makes a derivative work, which means a work based in a primigenia or original work, even because it transformed it, traduced, translated, or in any other way it's based substantially on the original work. For example, if you transfer a book to a movie, in this case, you require the authorization of the original author. And normally, the payment of some compensation, some royalties for the use of that original work. So what will happen if a program of artificial intelligence, you order the program to create a script, a cinematographic script, based in certain books previously established, or that you give instructions to create a new song based on certain songs already established. Are those cases equivalent to the same thing? To give credit to the original work and pay the royalties corresponding to its use, or it's a different case? A very interesting alternative would be to determine that when we are in the impossibility of identify any of the original works used to generate the derivative work, then everything has to be considered public domain, uh, including the small parts, the non-substantive parts of the original works, as the works produced by artificial intelligence. So it's like if we ask the artificial intelligence that takes 3 musical notes from each song and do it from 100 songs to create a new song with 300 musical notes. That we will only take 3 notes in a row from each original um, song taken, but obviously the result will be completely different. But at the end of the day, we are taking the notes from the original song. So it's difficult to determine if what will be the origin and to cite all the songs where we are taking that information, but that may be a solution. This interpretation and the opposite, it will give a citation if it's a result of jurisprudence that says that the right to citation is established in the federal law in the Article 148 of the Mexican law, and the objective of this right is to interpret the correct way in the cases, the particular cases, have to be accepted for citation or not, and do not obtain an economic advantage out of the thinking of other people. So remember that when we talk about royalties, for example, in the copy machines, the photocopy machines, we cannot really determine exactly which book we are copying and to give the royalty specifically to the author of that book. So that's why the collective associations in Mexico, Sociedades de Gestión Colectiva de Derechos, they just charge like a quota of all the copies that are made, regardless if they are copyrighted or not, because it's a practical way to pay for it. Otherwise, it's going to be very, very difficult to do. So, well, additionally, for the obtention of information of artificial intelligence in the World Wide Web is equivalent to the obtention of illegal information if the fact that information is digitalized and accessible on the internet. That doesn't give you free use to everyone about all that information. It's public. But maybe the copyrights already expired, and maybe the rest of the information is public domain, but other part of the information still has copyrights, and artificial intelligence does not make any difference among both. So that's a very important issue, because a lot of information that is on the internet is no longer protected by copyright and is public use, and many other information is still protected for the years of protection, and artificial intelligence cannot distinguish one from the other one. Also, we can legally stop the artificial intelligence from obtaining information from the internet. Maybe we can do that, but the way it takes the information is like that. It's similar to the ripping of information, which is not a court in Mexico has said that you cannot proceed with the parole about that impediment. Okay, so against the order to block an internet web page in which you offers to the users that possibility, the court say that that will contravene the rights and the disposition of public order, and that will affect the social interest. Not, not as accepted, at least in a similar case of stream reaping. So um, other topics give the artificial intelligence or the creators of computer programs certain degree of rights of participation. I do not share that proposal because the artificial intelligence cannot be an author because of the reasons already explained, and also it cannot be a co-author without participation, and that legally gives them rights. So I don't think that's neither a solution to try to share uh, as a co-authors with artificial intelligence. And the same situation applies with uh, everything that is produced by robots, in the sense that you cannot consider the result of an intellectual process when the results are exactly the same as produced by human beings, because the law has said that they have difference, and in essence, they are not produced by the same result. So also people try to create enabling right of artificial intelligence, like editors of books or interpreters, but I don't think they don't fulfill the requisite of humanity and personality already mentioned, so that's not possible to consider it. And another discussion is the case in which work can be generated by artificial intelligence, but is registered by a physical person in its own name. So the artificial intelligence created the work, and I registered under my name. There have been certain cases in which they have tried to do that, and it has denied the right to do it. But the problem is that in certain cases, or many cases, the authority will not know that that work was created by artificial intelligence. So in the present, I think it's happening, and the future probably is being more common, even more common, that you will not be able to distinguish something created by a human and something created by artificial intelligence. So that would be a huge problem because if someone registered it, the authority will not be the possibility of distinguishing. So probably we will have to implement a change in the law and make a requirement that you declare that you are personally the author of the book, okay, and not only that you take it from artificial intelligence and you are registered it as the author of the book. And the last topic that I would like to mention is some people suggest that we need to create a special regulation or a specific legal figure to the words that are created by artificial intelligence, but I think it's not necessary because the state of the advance of that topic uh, is not is not yet required. In the future, it will be necessary to create this legal figure, but making a very detailed analysis of the objectives look that we're looking forward with that possibility, and in order to determine the negative consequence that can be from accepting that. Because at the end of the day, the copyright, what they pretend is to to increase the protection to create more works. If we allow this figure, then what is going to happen is the creations of the works made by humans are going to diminish, and the quality of the originality of their works also is going to be affected, and the economic benefits and the recognition is also be affected. So at the end of the day, I think that to give legal rights to artificial intelligence or the works created by artificial intelligence, it's gonna be in detriment in the of the human creators, and I think that's not the purpose that we want and that we were looking for when the copyright laws were created. So what we want is to promote that people, persons, human beings, create more things to be creative. And if you are going to find a way that artificial intelligence can do it in seconds automatically and cheaper and easier, that's going to be like an unfair competition, and probably that's not the result that we are looking for. Well, basically, I think those were the most relevant issues that I wanted to mention on this participation. Thank you very much for your attention, and well, I hope to keep talking about these topics in the future. Thank you very much.